and welcome to Risky Business, managing your risk in 5 minutes or less. I'm Idra Anderson, Vice President of Risk Management and General Counsel for the San Antonio Board of Realtors. Today's topic is trust accounts. Now, this is a huge topic and one that could really be the subject of a 3-hour MCE course, much less a segment of only a few minutes. So our discussion today will be targeted toward when a license is required to handle a real estate trust account. I recently attended the Texas Association of Realtors winter meeting in Austin, and one trust account issue gained a lot of attention. When does a bookkeeper for a trust account have to have a license? During its most recent session, the Texas legislature amended the Texas Real Estate License Act to clarify that a license is required to accept or control the deposit of rent relative to single-family housing when done on behalf of a third party and for compensation. The Texas Real Estate Commission then passed a new rule interpreting the law, stating that a license is required if a person has the authority to use the rent to pay for services related to management of a property. Additionally, if a person has the authority to both deposit rent into a trust account and sign checks or withdraw money from the account, then a license is required as well. Now, in that second prong, both of those elements must be present to implicate the license requirement. So, for example, if you have an unlicensed assistant who's tasked with taking all rent checks down to the bank on the 4th of the month to be deposited, but that's all that person is authorized to do, then TREC doesn't require that person to be licensed. The trickier situation involves a bookkeeper who has the authority to sign checks relative to the trust account. It's likely that person will have to be licensed, not because of that second prong, which requires deposit and signing authority, but because of the first prong, which requires a license when authorized to pay for services relative to management of a property. So even if you were to have in your written policies a statement prohibiting that person from depositing checks, since he or she may also sign them, because those checks will likely go toward payment for the services relative to the management, a license will be required for that person with check signing authority. So those of you with property management companies or who regularly practice property management, you probably have trust accounts in place already. But remember, any real estate licensee who holds money on behalf of another person may only do so via trust or escrow account. So while trust accounts may at first blush appear to only apply in the property management context, they really apply to you all. So be sure to discuss with your attorney the steps your company needs to take to remain in compliance with the law and TREC rules. You may also feel free to contact me at the board with any general questions. As always, I hope this has been helpful to you. Be sure to post your tricky situations on LinkedIn. And for now, here's wishing you more business and less risk. Take care.